While the jury is being brought in, I want to bring in my guest for this hour, national trial attorney Mike Jaafar, who joins us in studio. So you heard the judge there, Michael, saying that she's denying the defense being able to take this line of questioning. The state said, look, we didn't have a chance to prepare for that line of questioning. We need to bring in a pharmacologist, a psychiatrist in our rebuttal case, and that's expected to go forward on Monday. Is that a problem?
For the defense, I don't think it's a problem for the defense. I think the judge made the right ruling because at the end of the day, this matters. How much weight the jury will give it is an open question, but I could see a situation where because that's why the judge said, depending on how the testimony evolves, I might, consider other objections. Depending on how if the defense
so there's still a chance.
There's still a chance. If the defense comes out there and says, well, that's it, ipso facto, she took the medication, she's not a zombie, that means this is, evidence of the fact that she has schizophrenia. I don't think that they'll be able to, if they do go down that line, it might actually delay the trial for the prosecution to bring in, rebuttal witnesses.
All right, let's go into court and see that first defense witness of the day, the last two of the experts that they are going to be calling to the stand. All right, they are taking a quick bench conference with the judge while this expert is on the stand. Let's bring in our guest for this hour, national trial attorney Mike Jaafar. Michael, you heard the psychologist there saying that she doesn't have a history of childhood trauma. She doesn't have a history of anger. Do you think that's going to help this jury, just the fact that this was so sudden and such an anomaly in Sidney Powell's life?
It should. If the jury is rational, if the jury really takes stock of the evidence and of the science, and they listen to these experts, they're going to make the right decision, which is that she probably is not guilty by reason of insanity. I have a strong belief that they're not going to make the right decision. I've discussed it with friends. I just don't believe that this jury is going to take that leap, although, in my opinion, as an attorney, they should. I've looked at the science, I've looked at the evidence, I've argued these cases. They should do that, but an Ohio jury is going to be they're just going to ignore the overwhelming evidence from these experts, and they're probably not going to buy it, but they should.
I know you're basing this on being not only an Ohio lawyer, but you've dealt with cases involving insanity pleas as well. That's a difficult task for this jury when they've got to learn everything there is to know about this unique condition in 2 weeks. Is that enough time for a jury really to be educated on the ins and outs of schizophrenia?
I like the way you laid it out. Is 2 weeks enough? I don't think so. Ever since, John Hinckley was acquitted, found not guilty of trying to assassinate the president by reason of insanity, the whole country has just taken a turn against these defenses, although they shouldn't have. It was an overreaction. One state even abolished it entirely. How could you abolish just a scientific thing? And in Ohio specifically, they have a Supreme Court case that says even if you find somebody insane, right? If while they were insane knew that they were harming somebody, doing something wrong, they're normal guilty as a sane person, which, how could you do that? I just don't agree with it, but that's the state of the law where this case is taking place.
And that may be a jury instruction that these jurors will have back there with them in the deliberation room.
Portion of lead
All right, let's pause the testimony to welcome our guests for this hour, criminal defense attorney Bob Mata and national trial attorney Michael Jaafar. Apologies, Michael. You just made a comment that I want you to share with viewers, and that is about the demeanor of the defendant. Julia Janae pointed out that during the doctor's testimony, she's been using her hand a little. She looks different. What did you notice?
What I've noticed is with every other witness that's been on there, she's been a complete puddle. She's been in tears, she's been crying. But when this expert was in there, and when the other expert, both doctors that have examined her, she's very calm, very composed. Her body language is completely different, and it has, in my opinion, it has to do with the fact that they give her a comforting feel because they've treated her, they've sat with her, they've talked to her about in ways that her family and her friends just cannot do it because they're professionals.
That is fascinating to me. I'd love for viewers to weigh in, let us know what they think, because it is definitely a different demeanor. I agree with you there.
All right, joining us to discuss is national trial attorney right here in studio, Michael Jaafar. Michael, great to see you again. Thanks for joining me. Let's begin right there with that motion to reduce bail. They wanted to have her released on her own recognizance. Right now, $80,000 sitting there with the court for her bail to ensure that she comes back to court. They say she needs that for her defense. It's an issue that as a defense attorney you face all the time. They're running out of money, but the court's holding this money. We're going to come back and forth, and what they did is they laid out the weaknesses in the state's case, saying, look, we believe eventually she's going to be found innocent. She's not going anywhere.
Yeah, we saw them a few months ago come into court and bring exhibits. So, well, they said that a dog bit his arm, but these are from glasses. So they've already presented evidence. I completely agree with them. Look, how often do you see a serious, credible claim of you being framed by law enforcement officers? It's very rare. We see it in movies, but we don't see it in real life. They're making some outlandish claims. She has great attorneys. They may have a point, and if they're right, it's more important that they prove that they're right and have the ability to do it than to save a little bit of money on bail. She's clearly not going anywhere. So what's the point of the bail, right? Let her defend herself. Let her justify her claim. I'm curious. I want to know, was she framed by a bunch of police officers and there was a cover? I want to know that. You're making that claim. Let's see.
Listen, that's what I want to ask you about, making that claim in open court. You know this is being televised. You're in this town, and you're making that kind of claim. Now, defense attorneys will say what they have to say, oftentimes with even the slightest amount of evidence. Here, they've got some pretty good evidence that there are some issues in this case. You got at least what looks like lying about whether there was a snowplow down that street that night at the time, early in the morning, which would have seen a body, which they claim wasn't there. You also have the same officer going back doing unauthorized and undocumented searches of the property, and you also have him withholding evidence from January 29th to March. And apparently there's some evidence on that clothing that kind of ties her to the crime. They're saying he had a part in maybe placing it there. There's a lot to work with. They called him in open court corrupt. I've never seen such a thing.
I've never seen it. I remember when I first became a public defender, my first day at work, I was handed 20 cases. A good 6 or 7 of them said I was framed, and I ignored them, right? And I went to my superiors, hey, this guy's saying he's framed. Everybody says they're framed, right? And I was trained as a young attorney. Look, everybody says they were framed. We would just make jokes with the prosecutor. Hey, well, cops planted, marijuana on my client. It was an open joke. It's a common thing, but defense attorneys never take that seriously. This is a great defense attorney, and he's taking it seriously. He's staking his reputation on it, his family's reputation. So I agree with you. There's a lot of inconsistencies. Let's see what happens.
Yeah, she's got a lot of support, and the police attorney got enforced to support the cops in this instance. So this is one we've got to keep an eye on. Quickly, I want to go to Pursehouse. We heard today testimony, something that really jumped out at me. It was a small thing. You found rosaries in one room, and they were broken. And the beads kind of left a breadcrumb trail all the way to the balcony. To me, it sort of laid out this picture of him with his hands around her neck. This thing breaks, and he's dragging her as these beads fall to the balcony. To me, it's a small thing, but it's something that could loom big in a case like this.
Never thought about it until you explained it that way, and it makes sense, because think about it like this. Let's just say he's right. Let's just say she died, and it was a tragic thing, and he didn't intend to do it. He was on a date the next day. He was on a date the next day with a stranger, right? So to me, I'm just imagining this poor, frightened woman finding this guy in her. It's the epitome of a nightmare. If you're a young, small, frail woman, a man that you're afraid of. She had PPOs against him, restraining orders against him. So I agree with you. Yeah, that image came to my mind when you described it.
Yeah, absolutely. And a good prosecutor might take that opportunity in his closing to describe it exactly that way, and it becomes much more vivid. And again, it goes along with the fact pattern and his background as well, and the situation as it existed. So I think it was a little bit of evidence that could turn out to be very big. All right, Mike, stand by. We're going to take a break here now. Still with me here in studio, Michael Jaafar, national trial attorney. And Michael, one of the issues that has been brought up now with this particular witness is about an audio mail that was sent, and it regards a woman that he met on Tinder and went out with her, as you mentioned, the day after this murder. Number one, his whole demeanor that day is food for thought, right? Because you mentioned there's just the way he's acting, it seems odd. Just the night before, someone apparently had an accidental death, right? Not mentioning it. She says he doesn't mention it. But the other issue is he's got some marks on him. And the issue now is they're trying to clarify whether there was a bruise on his eye, whether she called it a black eye. First of all, does it really matter? There was a mark on his face and there were scratches on his neck.
It doesn't matter. You know why, Michael? Because he never called anybody. If it was an accidental murder, he didn't call anybody and tell them. You could say, well, he was shocked. He was on a date the next day. That's not indicative. That's indicative behavior of somebody who did something where he didn't even try to cover up the murder, right? So, yeah, I don't think it matters. It actually hurts him. But I don't think there's anything he can do at this point to not be a villain. He's a villain.
Yeah, he's a villain. Yeah, and I think, and yesterday we were talking a little bit about this issue regarding the suicide risk expert. I got that clarified, but right now it looks like the sidebar is over. So let's get back into the court for more of the testimony of this detective. All right, let me bring back in my guest, still with us, National Trial Attorney Michael Jaafar. Michael, the judge has been very active in this case, and I think it's been noticed by a lot of folks online. I've noticed it from the very beginning. He's very much involved. There are times where he'll paraphrase what some of the witnesses were saying, and he'll point out what the questions are, you know, without any kind of consultation with the attorneys. You see here, it seems like he's trying to keep this trial moving along. Your thoughts on that, and whether that is something that you like when you're trying cases?
I don't. I think your observation is correct. He wants to keep the case moving forward. I don't like that because it disrupts the theater. It disrupts the flow. If you're a prosecutor or a defense attorney, there's a flow to a case. And we've seen multiple cases just today, and we've never seen a judge be so active. He's very, very, very active. He's basically talking just as much as the attorneys. He's moving cases along. He just told them, yeah, I'm not going to be okay with these sidebars. Have you ever seen a judge tell you, this is the last sidebar you take with me? I've never seen that.
I've never seen that, but I have had judges call the attorneys over and say, look, you're going to have to start figuring stuff out here because all these objections, all these sidebars are getting on my nerves. You know, I've heard them do that. You know, I never say, okay, we're not going to allow any more. But certainly it can upset a judge when he's trying to get this thing moving and everybody's objecting to everybody else. So, all right, it looks like that sidebar is over. Let's get back into court. All right, so it looks like let me bring back in my guest, Michael Jaafar. And Michael, it looked like there at the end, there was a little bit of a twist, because we had heard at the end of the cross-examination by the defense that she never asked him why he had this thing on his face. But it sounds like there at the end that the detective on the stand did not agree with the statement that she never asked him what happened to his face. Can you decipher what was going on? Because I can't.
I think this whole thing has been bizarre.
Yes.
It's been completely bizarre. Leading up to that point, his testimony was just outrageously hearsay, right? That's pretty much what I saw. And I was looking for an objection to the hearsay objection, and I couldn't really find one. And, you know, at the end, the defense attorney did say, you know, calls for speculation. I agreed with her. But no, I can't make sense of this. This kind of is puzzling.
Yeah, and it's such a fine point. And again, I couldn't discern why it mattered. I think what's important here, at least in my mind, is the fact that there was a mark on his face. Now, if it was clear that he had said to her, oh, I got it while I was doing some work on the house, or I was playing with a kid and I got hit in the face. If he lied about it, then maybe you got something to work with, but I haven't seen anything that suggests that happened.
You know what I think, Michael? I think the reason that any spectator would be confused about this, and so am I, is because the defense knows something that we don't know about the defense. They're about to put on a defense where this seems to have really touched a nerve for the defense, not so much the prosecution. And even the judge is getting frustrated with them. That's why he wants to keep it moving along. They're about to present a defense where this is going to come back and really matter heavily. It's the only thing I could think of.
Yeah, and you make a fantastic point, because a lot of times as we sit here, we don't know the strategy, we don't know the exact story. We know the generalities, right, that they think it was an accident, but the importance of that injury and whether she asked him or not what had actually happened is maybe something that they're going to pick on and use to their advantage. And we don't know what their strategy is in the finer points.
I completely agree. The defense are going to put on their case in chief, and this seems to have really struck a nerve with them. And I'm really curious to see what they put on, because at this point, there is really nothing left available to them. But this has seemed to strike a nerve, and I think that's why they're, pigeonholing the prosecution in a certain way.
Yeah, it's interesting. And let's talk quickly about that defense, the idea that this was an accident. You know, how does that work? I mean, clearly, it doesn't seem to me at any point they're suggesting he wasn't there. And it's difficult because there's some video that you can clearly see that it's pretty much him there. At the end of the day, what are they trying to do with this particular defense?
In the modern day era where we have technology and cell phones and cameras, defenses have evolved, right? 50 years ago, as a defense, it was a credible defense to say, this was not my person. Just think about it. If there's no cell phones, if there's no cameras, he could have done this and they would have said he wasn't there. There's nothing that ties him to the scene of the crime. Every single defense now has to grapple with the fact that you're tied to the scene of the crime. So what are they trying to do? I think these are a bunch of Hail Marys. We saw some Hail Marys in cases earlier today. And I think it's just a Hail Mary defense to say it was an accident. You know, he was there, he loved her. I think it's going to work.
Yeah, I think it's definitely a tough hill to climb. And you're right. I wonder, without all the technology and the video, et cetera,
Wasn't there.
if they ever would have even got to him. I mean, they would have looked into him because of their history,
Yeah.
but would they ever been able to tie
I
him to this
wasn't
crime?
there. It wasn't
Not
me.
sure.
My fingerprints are not there. I
sure.
cleaned everything. Yeah.
All right, Michael Jaafar, thank you so much for joining me here in studio,
pleasure.
coming into Atlanta. Truly appreciate it. Really a
My
pleasure
pleasure.
to have you on the show.